Court. Clerk, please open court.
Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone, and welcome to your Supreme Court of North Carolina. This is indeed a historic day where we are holding our oral arguments virtually due to social distancing requirements. We are excited about this day and are thankful that we have hopefully gotten through most of the technical difficulties. So we certainly welcome Mr. Learberg and Mr. Cash and all of those of you who are viewing oral arguments today. Mr. Learberg.
Thank you, Your Honor. Madam Chief Justice, may it please the court. Just before trial, Judge Hobgood, the Superior Court judge here, was asked to make two judgment calls. First, whether plaintiff's sole expert was qualified under Evidence Rule 702B to second-guess the decision that WakeMed's hospitalist had made, their critically ill patient, Ms. Pierce. And second, whether that expert's trial testimony, which the Superior Court had in hand as a de bene esse deposition, was enough to show proximate causation when the expert never said that the defendant's actions caused Ms. Pierce's injuries. In its discretion, the trial court disqualified plaintiff's expert on both independent grounds and accordingly entered summary judgment. Now, this court has repeatedly deferred to such trial court decisions in admitting and excluding experts, but the Court of Appeals reversed anyway, substituting its judgment for that of the trial court. Because the trial court's decisions were not an abuse of discretion, the Court of Appeals decision should be reversed and the trial court's award of summary judgment to WakeMed reinstated. Now, the first issue before the court is that the trial court did in fact properly exercise its discretion in finding that Dr. Jennison did not meet the requirements of Rule 702. Rule 702B has been on the books for 25 years now, and the requirements and the meaning of this statute are by now fairly well established. The first thing that a court needs to do when examining the rule at the trial level is to identify whether the defendant was holding herself out as a specialist. Here, it's undisputed that WakeMed's hospitalists did in fact hold themselves out as specialists in hospital medicine. Under this court's precedent, including Wall versus Stout, that is sufficient for them to be regarded as specialists, and for good reason.
Mr. Learberg.
Yes, Your Honor.
Are you contending that any particular physician has the right to self-designate himself or herself as a specialist for purposes of Rule 702?
Your Honor, in part, yes. And the rule requires that the physician be a specialist at the time of the injury. So a specialist could say at that time, for example, in this case, 2012 timeframe, yes, I'm holding myself out as a hospitalist. An expert may not go back, or a defendant may not go back years later and say, oh, I was a specialist at that time.
Is there any limitation on the ability of a particular doctor to declare himself or herself to be the member of a particular specialty, or does there have to be some consensus as to whether that particular specialty is in fact a specialty? In other words, does the court have any role in determining what is or is not a specialty, or does the doctor himself or herself get to determine whether specialization exists?
Your Honor, it's not so much a subjective question as to what the physician intended at the time. Instead, the trial court in its discretion can examine the factual evidence and weigh whether or not that particular physician defendant was a specialist at the time. So, for example, this case is a good application of that rule. Here, the subspecialty or the specialty of hospital medicine is actually recognized widely. It's recognized by the American Board of Physician Specialties, the American College of Physicians. There are 60 fellowships offered nationwide. Some are for internists, but some are for other specialties. And all of these 60 fellowships provide training for those who want to go on and practice hospital medicine. And these are at some of the finest medical institutions in the country: Johns Hopkins, Brigham and Women's, Mayo Clinic, Cleveland Clinic. So
but there, you are conceding that the court has at least some role in determining whether a particular specialty does or does not exist.
Your Honor, I absolutely think that there has to be some limit, right? And there could be a case in which a physician was holding him or herself out as a specialty in an area of medicine that simply doesn't exist. But we know that that's not going to happen. And the reason is no physician is going to hold herself out as a specialist and risk the consequences of that unless he or she has some training. Here's why. A specialist is saying, by holding herself out as a specialist, she is saying, I am willing to be held to a higher standard of care. And she is. She could have performed admirably in the standard of care for a general practitioner, but if she's holding herself out as a specialist and a specialist come to testify that she did not reach the standard of care for a specialist with that training, then she can be held liable. So there's a natural give and take and a natural impetus for a physician to only proclaim that he or she specializes in things she actually has the experience on.
Go ahead.
I have a question about that. What do you contend is the deficiency in the qualifications of the doctor presented by the plaintiff here under Rule 702?
Yes, Justice Hudson, there are several. First, the specialty that the WakeMed's hospital is specializing is hospital medicine. And we know from Dr. Jennison's own testimony, he answered honestly in his deposition and his trial transcript. And he said, yes, I do the same thing as them, but only 2 months out of the year. And that's the year leading up to the injury. Under the statute, the legislature has decided to draw the line at majority of professional time. So the trial court's required to examine the facts, examine the evidence before it, and Judge Hobgood found the testimony to be undisputed. Dr. Jennison said, yes, I do practice hospital medicine, but only 2 months out of my 12-month year. That's not enough. That is where the legislature drew the line. And that line makes sense. The level of competence required to practice a particular kind of medicine is far different from the level of competence required to be an expert in it. A lawyer might dabble in bankruptcy court from time to time and feel competent and feel like he or she is representing her clients well, but that doesn't qualify that person to then testify as an expert against another attorney for failing to meet, the intricacies of the bankruptcy rules.
So, Mr. Weber, your argument is that he would have had to see patients in a hospital setting for 6 months in order to qualify under 702?
Your Honor, yes, with one caveat, and that is that Mr. Cash has made great hay of this idea of a setting, that the setting is what matters. And just to clarify, I don't think it's actually the setting. It's not focused on, the specialty is not focused on the particular room that a doctor is in. It's focused on the kinds of patients and the kinds of procedures that are required. But with that caveat, yes, Your Honor.
If Judge Hobgood had held that he was qualified based on these facts under Rule 702B, would that have been an abuse of discretion, or would it have been within his authority?
We would have a very difficult time, Your Honor, on appeal saying that that was an abuse of discretion. Under these facts, however, I think, and that's just because the Court of Appeals and this court hopefully respect that standard of review as being very difficult to overcome.
You just argued that he only saw hospital patients for 2 months out of the year. So under your own argument, why would it not have been an abuse of discretion if he had held that the doctor was qualified under 702B?
Your Honor, I'm just making the distinction that I think that would be wrong. Judge Hobgood would have clearly been wrong, but abuse of discretion is a very difficult standard. And I could see a court saying that it's a close enough call, or perhaps it was, there were other factual aspects in the record that could have steered it another way. The thing is, Your Honor,
if I could just follow up on that. Doesn't it matter whether Judge Hobgood was making a mistake about what the law is versus a judgment of the facts? And in this case, in the transcript, there's nothing where he explains why he's granting why he's excluding this doctor. The order doesn't give us any reasons or explanation or his logic behind it. And so in Justice Davis's hypothetical, if the reason he allowed the doctor to testify was because he was under the misapprehension that spending 2 months out of the year is sufficient to meet the legal standard, wouldn't we be at that point, shouldn't we be applying a de novo review and making sure that he applies, he doesn't have the discretion to decide what the law is. His discretion is about what the facts are.
You're absolutely right, Your Honor. And if it was clear on the record, and perhaps this is a case where it is clear on the record that 2 months simply is not a majority of a year. And if the trial court based his decision on a misapprehension that a majority of professional time means 50%, it means that's 6 months or more, then yes, by all means, the review would be de novo. In this particular case, the arguments that were made before Judge Hobgood, they were factual. I don't believe, and actually one thing I can't tell is exactly what is the legal issue that the plaintiff claims Judge Hobgood got wrong. This is unlike some of the early Court of Appeals cases that came out after the statute, after 702B was put on the books. In those cases, for example, in Formy Duval, the Court of Appeals case from 2000, there was a lengthy opinion issued by the trial court judge, 10 pages, and it was finding after finding and conclusion after conclusion. Clearly, in that case, as the Court of Appeals held, it was a question of statutory interpretation. Here, there's just no such question. There's the question of, was it a majority of the time? 2 months out of 12. There's the question of, what was the performance, the procedure that was performed? That's a factual question. There's the question of what specialty that these doctors held themselves out at. Justice Morgan?
Mr. Learberger?
I can't hear you. I think you're on mute.
Can I ask a follow-up question? Mike, are you on?
I'm on now. I did not realize I was on mute. Sorry.
Justice
Thank you, Justice Hudson and Justice Earls. But in terms of talking about this mathematical aspect, counsel, of 2 months out of the year, in talking about abuse of discretion, when you cobble together all that the plaintiff's expert had said from the standpoint of seeing patients every day, doing the same kind of work as a hospitalist, teaching hospitalists, and even having a broader scope of practice than a hospitalist, couldn't that be arguably an abuse of discretion from the standpoint of, as Justice Earls has said, perhaps a misapprehension of the law, looking strictly at the mathematical aspect of 2 months out of the year, as opposed to looking at the breadth of the plaintiff's expert's testimony?
Thank you, Your Honor. No, the math, I think, adds up here to be less than a majority of the time. What Dr. Jennison testified to is that his teaching and inpatient hospital time was confined to that 2 months out of the year. Now, it is absolutely true that there could be, this case could turn on the definition of the procedure at issue, which is a factual question. The trial court and WakeMed contend that the procedure at issue is the selection and administration of an IV antibiotic to a hospitalized patient like Ms. Pierce. The problem is, once the trial court made that factual determination, there just was no way for Dr. Jennison to qualify. He does not give IV medication in his outpatient clinic. He does not see patients who are deathly ill who have sepsis. If somebody like Ms. Pierce showed up at his clinic, he would send her to the hospital immediately. He can't give the IVs. He can only give care for people who are well enough to walk into his outpatient clinic. So once the trial court made the factual determination of the performance of the procedure at issue, the rest of it followed naturally, and there really was no further question of law. Justice Hudson.
Go ahead, Ron.
Were there findings of fact made about the percentages of the time the doctor spent?
Your Honor, there were none, and there's a reason for that. Generally, findings of fact, now absolutely in the Rule 9J context, which is separate, this court has held that findings of fact and conclusions of law are appropriate in certain circumstances. But this court has repeatedly held that the exclusion of an expert, which often happens in the fast-paced moments of trial or just before trial, that there's no need for findings of facts and conclusions of law and that they're not proper. Now, under Rule
Let me ask you a follow-up about that. Didn't the doctor testify in his deposition that when looking at the entire year about how much of his time was spent in seeing patients or instruction of medical students, that it came out to 55 to 60% clinical, looking at a year and taking consideration parts of the year that he's in the hospital, but also the other parts? I guess my question about that is, why wouldn't that be enough to qualify under the rule?
Sure. So, Your Honor, that testimony, it's divvying up his time into a couple different parts. First is the kind of 40 to 45% of his time that's administrative or office, that's actually not dealing with patients. It is true that he spends a majority of his time dealing with patients, but he admitted he only spends that 2 months of the year dealing with patients who are sick enough to be hospitalized, who need to be hospitalized, receive IV medications, and to face those kinds of life or death decisions that hospitalists make.
But didn't he also testify that he engaged in activities that included the procedure at issue here, i.e. the prescribing of the medication, all the time?
No, Your Honor, he did not. Now, he does engage in prescribing medications in general throughout the year. That is true. But there's no way, and it would have been an abuse of discretion for the trial court to find that prescribing medications is the procedure at issue. If prescribing medications or diagnosing illness and prescribing antibiotics, if anything at that level of generality were the procedure, then any doctor could testify against any doctor. In fact, a neonatologist could say that a gerontologist treating an octogenarian had made a mistake in choosing the right medicine.
Is it your contention then, Mr. Learberg, that in order let me back up a second, is it your contention that an internist, generally speaking, cannot be a similar specialty to a hospital?
Your Honor, I think that for most procedures that would be true. And this is a highly fact-specific question.
So I'm sorry, go ahead.
Oh, please, Your Honor.
No, I interrupted you. You go ahead.
I mean, the fact-intensive nature of this, as it pops up in the different cases that have gone before the Court of Appeals, show that you can come up with different hypotheticals where a particular specialist might happen to have a great deal of expertise in a particular procedure. For example, the one that pops up the most is a general dentist who happens to have developed a side practice of doing oral surgery. Well, that dentist then becomes a specialist and can testify against an oral surgeon because it's the same procedure. He or she is familiar with it. And that's the ultimate thing the trial court's looking for.
Is your argument then that in order for an internist to be qualify under the part of the statute that allows, under certain circumstances, a practitioner in a similar specialty to testify, in this case, that person would have to spend over half of his or her time intravenously administering drugs in a hospital?
No, Your Honor. I believe that's almost correct. The problem is,
for me, getting almost correct is pretty good. So,
but no, I can't embrace that exact position, and the reason is that there's no way that the legislature, as the amici proposes, that the legislature wants an expert to be able to show that he or she did that particular procedure 50% of his or her professional time. That's not what the rule says, and that's not what WakeMed is saying.
Right. So what to make sure that I understand what you are saying, what is it about the evidence concerning Dr. Ginnison, if I'm pronouncing his name correctly, that prevents him from being a similar specialist or a specialist in a similar area of specialty who, as part of his work, does the same procedure?
This is really a question of what type of practice Dr. Ginnison has the majority of the time. And the type of practice is a different question from performing a particular procedure. It would have been impossible for Dr. Ginnison to have performed this procedure 10 out of the 12 months leading up to the injury. Impossible. He couldn't have done it because he wasn't in a hospital setting. He wasn't caring for
So is the mere fact that Dr. Jennison was not practicing in a hospital full-time for more than half the year by itself sufficient to require his disqualification in your view?
It is for the particular procedure at issue in this case, yes, Your Honor. And that's a fact.
So it does not matter. It doesn't matter what he may know about the administration of the particular drug in question. The mere fact that he is not actively practicing in a hospital for more than a year, that by itself necessitates his disqualification.
Yes, the General Assembly had to draw the line somewhere, and where they drew the line was not based on knowledge, it was based on experience. Now, the states do this a whole range of different ways. But in North Carolina in 1995, the legislature said, we don't want professional experts. We don't want retired physicians who used to be at the top of their game coming in years later and testifying about the standard of care. The General Assembly said, we want active practitioners who are doing the same or similar specialty as the defendant for a majority of their time. And that's where the line was drawn. They could have drawn the line at 2 months or 1 month, but they didn't. They drew it at halftime.
Is then because Dr. Jennison practiced in a hospital for more than 6 months of the year, is he as a matter of law disqualified from testifying in this case?
Your Honor, yes, it's as a matter of law flowing from the facts that the trial court found.
So then do we have a question of law or do we have a question of discretion in front of us?
I don't think so, Your Honor. After the facts are determined, there's no legal question left. The statute can only mean one thing. And again, I don't understand exactly how plaintiff would frame what that legal question is. It's a question of whether this law as applied to these facts satisfies the rule or not.
And your contention is that's not a question of law, that's a question of discretion.
It is a question of discretion, yes, Your Honor. At that point.
Let me ask you a follow-up to something you said a few minutes ago in response to a question. You testified that if he were allowed to testify, that anybody could testify against anybody. And I guess my question is, when the issue revolves around whether a doctor should be prescribing an ongoing prescription of a medication that has a black box warning, shouldn't any practitioner be able to live up to that, to the standard of knowing and complying to that standard of care?
Absolutely not, Your Honor. This is not a case where the doctors missed or overlooked the black box warning. These hospitalists saw that warning and made a medical decision because they are hospitalists. It was better to continue the Levaquin that had been begun in the emergency department. They made that decision because this was a very sick woman. She faced a life-threatening sepsis illness, and the emergency room, a non-party, had already started her on Levaquin. By the time she came into the care of the hospitalist, she was responding well. Levaquin is particularly good for infections of the kidney, which it turned out is what Ms. Pierce had. And these hospitalists made the decision, looking at her overall care in the hospital, that it was better to continue this drug, Levaquin, because it, in the words of one of the doctors, it had saved her life. It was saving her life. So weighing those weighty factors that only hospitalized patients and doctors deal with, weighing that is what a hospitalist does. And
So,
absolutely what
position that only a hospitalist can make that kind of weighing determination about an ongoing medication like that?
Someone with experience in the hospital weighing those factors, absolutely. And there were 38,000 of them in 2012. There were 70 at Yale New Haven Hospital, where Dr. Jennison practiced. Their website lists 70 people who could have testified. But he's just not on the list. There's no reason that plaintiff could not have found a hospitalist to testify against these hospitalists, unless, and sometimes the record reveals this silently, unless they couldn't find a hospitalist who would say that, because hospitalists know that it's more important to save someone's life than to risk a 3 in 1,000 chance that someone will suffer a tendon rupture. 3 in 1,000 increased chance. These doctors made the decision it was more important to save her life.
Mr. Liebert, there's also a proximate cause issue in this case. Can you talk about that?
Yes, Your Honor. The proximate cause question in this case is revolves around the testimony of Dr. Jennison in his trial transcript. So we had his trial testimony. And what Dr. Jennison said in direct and in cross is that it was his opinion that Levaquin caused the injury. The problem here is that in his, that's probably not sufficient because there were 3 different places where Miss Pierce got Levaquin. She got it from the ER, then she got it from the hospitalists, and then she got it in pill form when she was at rehab. And Dr. Jennison, to his credit, he knew what the medical literature said. And there's discussions of it in the transcript, in his deposition and trial transcript. The medical literature simply didn't support what plaintiff was asking Dr. Jennison to say. And to his credit, he didn't say it. He said on cross, I can't say. I cannot go that far. What I can do is say that the hospitalist decision not to discontinue the Levaquin that Miss Pierce was already on, that increased her risk of injury. But increased risk is not enough. That is not proximate causation.
The Court of Appeals, in its opinion, it said twice that the doctor was unequivocal in saying that this was a factor. Why would that not be enough then in terms of you saying it doesn't go far enough when the Court of Appeals opinion says twice the doctor was fairly definitive, sufficient enough to have given a reputable opinion?
Well, with great respect for the Court of Appeals panel, that's not correct. They were not correct to the extent that they said that. The Court of Appeals panel misread the testimony of Dr. Jennison. The trial court who was there, that's the entity that deserves, and the person that deserves discretion and deference. The Court of Appeals, this court is reviewing the Court of Appeals de novo. And the Court of Appeals was wrong. Dr. Jennison simply never said that it is more likely than not that the actions of WakeMed's hospitalists caused Miss Pierce's injury. He wouldn't go that far because the medical literature doesn't support it.
But did the Court of Appeals really address that issue? I didn't really see that in the Court of Appeals opinion.
No, the Court of Appeals, it's a similar argument. It's a slightly different way of looking at it, which is this, Your Honor. The Court of Appeals focused on, in his cross, did Dr. Jennison undermine his direct testimony? And even if he had said on direct, WakeMed's hospitalists, their actions caused the injury, on cross, which is exactly what lawyers need to do, is probe the limits of expert testimony on cross. That's when he said, you know what, I can't go that far. All I can say is that it increased the risk, and that's not enough.
The Court of Appeals did not engage in an analysis as to whether North Carolina law recognizes an increase in risk, correct?
No, Your Honor. And the reason that we brief that is because the Court of Appeals does mention briefly the White versus Hunsinger case that says that an increased risk, which is what Dr. Jennison said on cross, that increased risk is not sufficient. So that is the current state of North Carolina law. I think that's undisputed. And to the extent that the Court of
question about his testimony on direct, the doctor said that unequivocally, as the Court of Appeals said, it was the cause of her injury. At summary judgment, don't you take it in the light most favorable to the plaintiff and let the jury sort that out?
Well, Your Honor, no. For two.
It sounds like you're saying that the trial court is supposed to weigh the relative strength of the testimony on direct and cross. And my question is, why isn't that for the finder of fact?
No, Your Honor, for 2 reasons. First, Dr. Jennison did not say on direct that the actions of WakeMed's hospitalists caused Miss Pierce's injury. It's this testimony is on his trial transcript, pages 106 and 113. And what he said was, Levaquin was the cause of the tendon rupture. Levaquin. He didn't say the actions of these defendants. So that is the critical distinction. And he clarified on cross why he was making that distinction and being careful not to say that the actions of WakeMed's hospitalists caused this injury. And furthermore, a single witness cannot create a contradiction sufficient to survive summary judgment by testifying to 2 different things on direct and cross. So yes, absolutely, a trial court should hold witnesses to speaking consistently. That is true. Now, you're absolutely right, Justice Hudson. If there had been 2 different witnesses saying different things, then yes, there's no way that the trial court should have delved into that question.
That's not really my question. It's why don't you take it in the light most favorable to the plaintiff?
Well, Your Honor, I don't think there's any way to read it other than that it says Levaquin was the cause of the tendon rupture. And I don't know that light most favorable to the plaintiff applies to the internal testimony of a single witness. That's a question of weighing material facts from different witnesses. This is just like the question of whether somebody has a bad deposition and the next day files an affidavit that says all of the things the lawyer wished they'd said. That doesn't create a material fact.
But isn't that what finders of fact do all the time when people who are giving some testimony on direct and it's undermined on cross-examination, which is, of course, the purpose of the cross-examination. The finder of fact has to sort that out and decide which is stronger and which to believe.
To the extent there's a bald contradiction, it is up to the trial judge to reject any attempt to for a witness to rehabilitate him or herself by contradicting herself. But in this case, the court didn't need to go there. Instead, the court was able to harmonize the testimony, which was always the goal. And Dr. Jensen, his testimony read carefully is entirely internally consistent. He goes right up to the line, but he does not say what he would have needed to say to prove proximate causation. And Your Honor, I see that my time is now expiring. If I have any time left, I'd like to reserve it for rebuttal.
That is all of your time, Mr. Learberg. Thank you so much.
Your Honor.
Cash?
Mr. Cash, I believe you're muted. Mr. Cash, if you could unmute yourself.
Can you hear me now?
Yes, thank you.
I'm sorry. Thank you, Your Honors. May it please the court. I am Greg Cash. I represent the plaintiff Appellee in this matter. As the court is aware, this arises from a medical malpractice action filed in Wake County Superior Court. On the eve of trial, Judge Hopgood rendered orders that included disqualifying the plaintiff's standard of care expert, finding there was lack of proximate cause, and on the basis of those two actions, rendering summary judgment for the defendants for lack of proximate cause and a lack of standard of care testimony. This plaintiff appealed this decision to the Court of Appeals. The Court of Appeals unanimously by original opinion and after rehearing slip opinion issued unanimous decision reversing the trial court's findings. This court granted defendant's petition for discretionary review, and that's where we stand now. I would contend, Your Honors, that there are two primary issues in this case. One, whether Dr. Jennison, the plaintiff's standard of care expert, was qualified under Rule 702 of the North Carolina Rules of Evidence to render standard of care opinions against the three WakeMed physicians. And two, whether there was sufficient evidence of proximate cause to enable this case to go to a jury. I would suggest the court and standard review for both of these issues are a de novo review. And I anticipate the court may want to know why that we take that position. And let me address that now. The order in this case in which the Honorable Robert Hobgood ruled upon defendant's motion to disqualify Dr. Jennison as an expert witness pursuant to Rule 702B of the North Carolina Rules of Evidence is found at page 185 of the record on appeal. The language used by Judge Hobgood in entering this order of disqualification is as follows. And appearing to the court after hearing arguments of counsel and reviewing authorities submitted by counsel that Dr. Jennison does not meet the requirements of Rule 702B. And the defendant's motion should be granted. He goes on to say that he is disqualified. It is the plaintiff Appellee's position in this matter that Judge Hobgood's decision was based upon an incorrect interpretation of Rule 702B, specifically as to the trial court's interpretation of the terms same specialty, similar specialty, prior experience, and similar patients, which includes the performance of the procedure which is the subject of the complaint.
So, Mr. Cash, what do you, Mr. Learberg said he didn't think you could state what the issue of law was, or that you had not done so to this point. What is the issue of statutory construction that you contend that we need to resolve using a de novo standard review?
My contention is, Your Honor, that in this case, the trial court misinterpreted Rule 702B to the extent the trial court made an error of law requiring this expert witness to spend more than 50% of his time in a hospital setting.
All right, so your issue, state to me as simply as you can for simple-minded people like me, what legal that we need to resolve is? What statutory construction issue do we need to resolve?
Your Honor, and I think that there's some, just to address a little background fact in the case before I address the legal issue. In this case, it's clear there's no dispute. Dr. Jennison is an internal medicine board certified physician, as are the 3 WakeMed physicians in question. They're all internal medicine board certified. By virtue of that, they're specialists under Rule 702B. The analysis the court is required to undertake is whether or not, as specialists, Dr. Jennison would qualify under Rule 702B. In this case, there's an issue. I would contend there's an issue as to whether or not Dr. Jennison is the same specialty as the 3 WakeMed physicians. First off, despite the assertions by Mr. Learberg, I would respectfully suggest to the court there is no recognized specialty either under as a subspecialty of internal medicine or as a standalone specialty of hospitalists. The materials cited in the brief by the defendant in this case cite to a number of articles and treatises that support the idea that hospitalists should become a standalone specialty. But as it stands right now, there is no specialty of hospital medicine.
Is there some objective standard that you could point to for when someone is or is not a specialist?
I think board certification is, under the Formative case, is the ultimate criteria. Is the first level of inquiry.
Is it the only one?
That was going to be part of my argument, Your Honor, in that I think this is a case for the court to enable the court to give practitioners like myself and the trial courts a framework to determine how to establish what a specialist is or what the specialty is. There's framework establishing. It says essentially when someone has a board certification, they're a specialist. They're not a general practitioner. But there is no guidance either through the legislature, either Court of Appeals opinions or by this court as to once you establish the expert, be it the defendant or the defendant doctors or the standard of care expert testifying against them, once you establish they're an expert, there's no real guidance on, specialists, there's no real guidance on determining what that specialty is. I say inherent in this evaluation, both by the trial court and the Court of Appeals, inherent in that problem is the defendants in this case have repeatedly requested that the court find the 3 WakeMed physicians as specialists of hospitalists.
Excuse me, Mr. Cash, when you say that the board certification is what's required to determine a specialty, must that board certification specifically be administered by the ABMS?
The ABMS is the institution which manages and regulates all board specialties. They all report to the ABMS. The ABMS recognizes or does not recognize specialties, and I suggest to the court that the ABMS is that institution which is responsible for determining what is a medical specialty and what is not. I suggest, Your Honor, that the problem here is when you have an institution like that, that it is in the medical field and governing medical specialties that doesn't recognize a hospitalist as a specialist, you run into deep, heavy water when this court says a person is a specialist of a hospitalist when it didn't recognize the specialty.
Mr. Cash, let me ask you a follow-up. As I understand your argument, and correct me if I'm wrong, that whether or not Dr. Jennison was of the same specialty, if there is one, is not dispositive of whether he qualifies under the rule. Is that?
Absolutely, Your Honor, and thank you.
And can you
Rule.
explain your interpretation of the rule that would lead to that position, if you would?
Thank you, Your Honor. Rule 702B 1A and B state essentially, Your Honor, that with regards to a specialist, any expert tendered to testify against that specialist giving standard of care testimony must specialize in the same specialty as the party against whom he's testifying. That's 1A. 1B says, or a similar specialty, which includes within its specialty the performance of the procedure that is the subject of the complaint, and have prior experience treating similar patients. This court actually, Your Honors, in Preston, acknowledged that the rule espoused here by the defendants is not the rule. This court in Preston, just in Preston v. Muhammad, said this January in issuing their opinion in that case, noting that, and that was the court was discussing witness qualifications and testimony in Preston v. Muhammad, which was also a 702B case found at 840 Southeast 2nd at 174. The court, in discussing whether plaintiff's counsel could have reasonably believed their expert or cardiologist would be qualified to render standard of care opinions against a nuclear cardiologist. In discussing the statutory requirements of 702B, this Preston court said, with regards to plaintiff's expert, Dr. Tokaroff, the rule, referring to Rule 702, only requires that an expert witness have experience performing the procedure that is subject to the complaint and treat similar patients. Not that the defendant and the testifying witness have the exact same professional qualifications. That mirrors language in Edwards v. Wall that was really the only appellate decision governing the requirements under Rule 702B1A, B1A and B.
Let me ask a follow-up to that, if you don't mind.
Yes, Your Honor.
As I understood Mr. Learberg's argument, it also includes a requirement that the specialist under subsection 2 perform that particular procedure for the majority of the time of the year. What do you say about that?
Your Honor, that's I think the language in Preston, the language in Edwards v. Wall, and the plain language of the statute doesn't say that. I would suggest the court that these experts are all internal medicine experts, but if the court finds that there are similar specialties, I would suggest that the language of 702B1B says that when it's a similar specialty, that similar specialty include the procedure that is the subject of the complaint and have prior experience treating similar patients. There's no question Dr. Jennison treats these patients, as he said in his trial deposition on page 74, all the time in the hospital setting. This is not an uncommon type of presentation. You have many elderly people who come in with urinary tract infections, some of which are taking corticosteroids, some of which are not. He sees that all the time. But the language here in 702B1B says it includes within his practice the specialty, the performance of the procedure in question. Mr. Learberg goes to great detail, great lengths to try to suggest that because Dr. Jennison didn't order IV antibiotics 12 months out of the year, he's disqualified. It's not the case. No hospitalist or internal medicine doctor inside a hospital setting is actually administering IVs. They write the orders for IVs. And Dr. Jennison did that 2 months out of the year, specifically for patients like this. As Dr. Jennison noted, his criticisms were, when you look at this box warning, and the specific warnings on that box are for this patient, Dolores Pierce. There were 15 antibiotics that could have been given by virtue of the antibiogram done at WakeMed. It identified the organism, identified 15 antibiotics that by WakeMed's pathology said would kill this organism. Dr. Jennison spent, I think, about 20 pages in his trial, in his discovery deposition with Mr. Madden, going over what other antibiotics were appropriate. And what his criticism is that there were a number of those 15 that were equally effective at killing this drug, but were not taken. And these physicians that ordered the Levaquin put Miss Pierce in a bad way. And to step to the proximate cause issue just a little bit for a second, Dr. Jennison.
Before you do that, Mr. Cash, I want to go back to standard of review. You seem to be arguing as a matter of law that Dr. Jennison qualified under 702B. And even though Mr. Learberg started out with abuse of discretion in his argument, he really seems to be arguing as a matter of law he doesn't qualify under 702B. And our case law really does repeatedly talk about this being an abuse of discretion ruling by the trial court. So under your argument, and what aspects of the trial court's ruling here were subject to an abuse of discretion standard?
And Your Honor, I would contend that as a number of the justices have picked up on, that this is a de novo review. Normally, I agree, normally the courts acknowledge that standard review on appeal is de novo. I'm sorry, the standard appeal for witness exclusion is an abuse of discretion. However, and the Court of Appeals in the Edwards versus Wall case pointed out clearly on this is the same issue we have in this case, Your Honor. The Wall decision, Edwards versus Wall, the Court of Appeals opined where an appeal presents questions of statutory interpretation, full review is appropriate, and a trial court's conclusions of law are reviewable de novo.
I'm asking you, on the facts of this case, what aspects of whether or not Dr. Jennison was qualified to give an expert opinion on this issue were subject to a discretionary ruling by Judge Hopkins?
Your Honor, I think the order, I don't think there were any, Your Honor. I think the order, I think Judge Hobgood substituted his, he took his credibility of the witness and made a credibility determination himself. His order, Your Honor, specifically says he disqualifies this witness under Rule 702B. That's in his order. There's no discretion noted in his order. It's all by virtue of the statute.
I understand your argument, but what I'm asking you is the issue that was before Judge Hobgood as to whether Dr. Jennison should be allowed to give an opinion. Was any aspect of the decision before him discretionary, and if so, what was it? That's all I'm asking.
I'm sorry. I would contend, Your Honor, the motion as placed before him was a motion which suggested that, and the argument suggested that solely that the purpose of the motion to disqualify was that he was not capable of testifying by virtue of 702B. So I would suggest that none of his order, I'm sorry, Your Honor.
Just a quick, don't we have case law that says that if the trial judge is misapplying the law, like misinterpreting Rule 702, for example, that's by definition an abuse of discretion?
Thank you, Your Honor. And Your Honor, it is correct. I would say that if there is as you point out, Your Honor, if there is a misinterpretation of the law, that would be abuse of discretion. I think the court in this case, and I think in Crocker, the Supreme Court in the Crocker decision noted that the issue for the trial court is once there is sufficient evidence of testimony of breaches in the standard of care, then it's a matter for the jury if the witness is qualified. And I think that the trial judge either, the court can find either on a de novo review or an abuse of discretion review that there was sufficient evidence for this witness to give testimony. And I believe that in this case, the defendants misinterpret what the rule is. If you examine the defendant's arguments by brief into this court, they apply the standard of Rule 702C, which is a general practitioner standard, and the general practitioner standard is the standard that was used in the former Duvall case. That case was a general practitioner, and the language that is quoted by the court in that case is language which is interpreting Rule 702C, which is the language is completely different from Rule 702B.
Let me ask this based on what you're telling us about the idea of what experts would qualify. Mr. Learberg gave the example of an oral surgeon, and then you had a general dentist who practiced oral surgery as part of his general practice. Would, under your view, would the general dentist who has an oral surgery practice qualify as an expert against the oral surgeon? And is that a matter of discretion or a matter of law?
Your Honor, I would say that if the general dentist had experience performing oral surgery procedures, and the criticism was as to an oral surgery procedure in question, I would believe that under our rules, under the similar specialty under Rule 702B1B, that he would in fact be qualified.
So that would be true even though he didn't have a particular certification. He was not, quote, board certified.
I believe so by virtue of his experience, Your Honor.
And would that be a matter of law or a matter of discretion as the trial court looks at the qualifications of the general dentist and tries to determine if he meets the criteria of 702B?
Your Honor, I think that the case law is clear that when the court's ruling is based upon a statutory interpretation, as a matter of course, the appellate courts review that statutory interpretation of the trial court on a de novo basis. So I would say it would be reviewable de novo, Your Honor.
So it's your view that it's a matter of law whether there exists a hospitalist specialty?
Yes, Your Honor.
Mr. Cash, I want to shift gears for just a second over to the proximate cause issue.
Yes, Your Honor.
I want to ask you about the position that the opposing counsel took, that the testimony that Levaquin was the cause of the injury couldn't possibly qualify as a proximate cause opinion. What, if anything, you have to say about that?
Your Honor, thank you for moving us. Let me say that as to proximate cause, there are a number of factors, and I'm going to talk about a number, but I think the backbone, the underlying backbone of everything goes back to the box warning. On top of everything else in the doctor's testimony, Levaquin says fluoroquinolones, of which Levaquin was a class of, are associated with an increased risk of tendonitis and tendon rupture in all ages. Risk is further increased with patients over the age of 60 and patients taking corticosteroids. This is Miss Pierce. She was 76 years old. She was taking prednisone, which is a corticosteroid. She was taking those concomitantly at the time that the orders were written by the WakeMed physicians.
Let me interrupt you for just a second. I'm sorry to interrupt you, but as I understood, the problem that Mr. Learberg has with the evidence was that it didn't testify that the WakeMed doctors were the proximate cause.
And thank you for redirecting me, Your Honor. let me say this, the test, the question may, as posed by me, maybe could have been done a little more artfully. I will say to the court that if you read the entire deposition of Dr. Jennison, immediately before going into proximate cause, we go through Dr. Jennison, by question with me, goes through the actions of each specific WakeMed physician, that is Dr. Jenkins, Dr. Daoud, or Dr. Afridi, and lays out specifically where they prescribed this medicine, either by IV or oral, because part of the time she was given IV Levaquin, part of the time it was oral, and at the same time, these same physicians are ordering prednisone. As a matter of fact, they increased the prednisone during a period of that hospitalization. And then Dr. Daoud, or I'm sorry, one of the three physicians, either Dr. Afridi or Dr. Daoud, issued discharge instructions that discharged her with further orders of oral Levaquin and oral prednisone while she was at a rehab facility. Dr. Jennison laid all this out, and after that, he talked about the doctors prescribing Levaquin on this occasion, prescribing prednisone. After all that, we go to proximate cause. He said the prescription of the Levaquin is what did it. I think that maybe a more artful question could have been asked, but it's clear he's relating the testimony he's already given about the doctors ordering Levaquin, he's testified. I will say the Court of Appeals said that he testified unequivocally twice. I would suggest that Dr. Jennison testified unequivocally 3 times in his trial deposition on page 106, 113, and 133. That unequivocally it was his opinion that the Levaquin prescribed by these physicians is what caused this this injury in this 76-year-old lady.
Let me interrupt you there, Mr. Cash. If I understood Mr. Learberg's argument correctly, he was saying that there's evidence from which you could find that the prescription of Levaquin generally might have proximately caused this injury, but there's no evidence, at least in his view, that the prescriptions by the 3 hospitalists caused it.
Your Honor,
he doesn't have rebuttal time, so he can't correct me if I'm misstating his position, but I think I've got it right. And what is the evidence that would support a jury verdict that the administration of Levaquin by these 3 physicians, given that there were prescriptions for Levaquin written by other people, what's the evidence that their prescriptions caused it as you see it?
Your Honor, at the trial level, I'm not required to show the proximate cause. I'm required to show a proximate cause.
Right, and I understand that, but what is the evidence that shows, in your view, what do you contend the evidence is that shows that the administration of Levaquin by Drs. Dowd, Afridi, and Jenkins was a proximate cause of the injury sustained by Ms. Pierce?
Again, Dr. Jennison testified on page 106, 113, and 133. And I don't have to read all 3 of those. I'm gonna read one of the 3 that is they're all very similar.
Right.
I mean, if you'd like for me to, but the doctor.
I mean, I'm happy with the general answer given the amount of time you got left. I just want to know what specifically you contend the evidence is that supports the finding that the prescription of Levaquin by these 3 folks, who are the ones that your liability claim is predicated on,
yes, Your Honor,
caused the injury.
Your Honor, again, I would suggest the court examine Dr. Jennison's testimony at pages 106, 113, and 133, and I'll summarize it briefly here. After going through the prescriptions by these 3 WakeMed physicians and identifying what he identifies as his what he contends were breaches of standard of care, he then goes on to say that those prescriptions of Levaquin to a 76-year-old woman with a corticosteroid, in this case prednisone, are, in my opinion, to a reasonable degree of medical certainty, what caused her injury. Contrary to Mr. Learberg's assertion, Dr. Jennison testified, in his opinion, these prescriptions by these physicians increased Miss Pierce's likelihood of this injury 3 to 10 times the odds ratio, raised her chances. And because of that, it was his opinion that it caused her injury. He testifies in the deposition about his review of peer-reviewed medical literature that discusses this very problem, numerous medical articles on it, and those all underpin his opinion, Your Honor.
Was that the extent of his opinion, that the decision that the prescription of Levaquin simply increased her risk?
No, Your Honor. His opinion was specific answer was that Levaquin, and this is again after describing the Levaquin prescriptions by the physicians, Levaquin was the cause of the tendon rupture that Ms. Pierce had within the classic time frame, less than 30 days of therapy, in the classic location, the Achilles tendon, under the circumstances that are described in the black box warning, an elderly woman treated with Levaquin while on prednisone. And that's a preventable complication that she suffered.
But did he overtly distinguish between the initial decision to prescribe Levaquin versus these doctors' decision to not discontinue Levaquin?
Your Honor, there was no distinction. She was brought in through the emergency room. She was started in the emergency room and very briefly thereafter sent to a telemetry unit of the hospital, not the ICU. She was not that critically ill.
Mr. Cash, thank you so much, sir. You are out of time, and we appreciate your argument. Thank you, Mr. Learberg and Mr. Cash, for participating in the first historic virtual oral arguments for the Supreme Court in its 200-year history. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.